Good evening. I'm Ron Bodinson, and tonight I will co-moderate the presentation with Gordon G. in Kansas. I believe everyone got a late note about considering having a pen and paper handy to take notes during the factual presentation by Andy. You don't need to take notes while I'm talking. So, as you probably already understand, tonight we will be placed in the shoes of jurors or a sentencing judge, or perhaps an appellate court for that matter, who must wrestle with the fair and just applicability of the death sentence. Capital punishment, as you know, is a front burner issue in the country from time to time. It's still on the books in 27 states and at the federal level. 13 executions have been carried out so far this year in 7 states. Yet the American people have not reached a consensus on the subject. Quite the contrary. A little more than half of us favor its use for convicted murderers. On the other hand, half of us no longer believe that it's used fairly. Our classmate, Andy Parnes, has extensive involvement in death penalty cases over the decades in his criminal law practice. Though he resides in Ketchum, Idaho, his practice extends into several Western states. Andy tonight will present us with 2 real-life cases raising the issue of fairness in the application of the death penalty. Once Andy outlines the facts, co-moderator Gordon G. will give the various breakout groups instructions on how to proceed to reach a verdict or a decision, and then report back to the group as a whole. I now introduce to you our classmate and legal star, Andrew Parnes.
Well, good evening. So what I'm going to do is to relate some facts on 2 cases that I actually handled over the years, and then you can determine what you think about them and so on. So let me just quickly go over these facts and that were involved. In 1980, Tom Gibson was a member of a motorcycle gang in California. While visiting another gang in Spokane, Washington, he was present at the time that 2 people, Scott Currier and Kimberly Palmer, were murdered over drug theft allegations. The 2 bodies were located near each other in a stream in Idaho. It's across the border for those of you who didn't take geography. The forensic evidence was that Currier had been dead before he was brought into Idaho, while Palmer was alive in Idaho. Gibson and 2 others were arrested and brought to Idaho and tried for the murder of Kimberly Palmer. The jurisdictional theory was that Palmer was alive when she was transported to Idaho from the house in Spokane and was left in the stream to die. The critical determining factor for the location of her death was the presence of water in her lungs. If she had died before being placed in the stream, her lungs would not have any water in them, and she would not have aspirated water when she was breathing. The forensic pathologist who testified at Gibson's trial testified under oath that she was alive when placed in the stream, and that was based on his analysis of her lungs. As there was no dispute that Gibson had been present both in Spokane and at the stream in Idaho, he was convicted and sentenced to death in 1982. The sentencing was by a judge at that time in Idaho. 13 years later, the defense uncovered notes from the state prosecutor. And how these notes were discovered was pretty random. I was involved in the case, and co-counsel was set to do a deposition on habeas corpus cases, and that deposition was to be held up in Coeur d'Alene, where the prosecutor resided. However, the the person who was to be deposed didn't show up, and the then prosecutor, who was not the prosecutor back in 1982, turned out to be a fraternity brother of a good friend of my co-counsel on the case. Since they had nothing to do, the prosecuting attorney said, well, why don't you just look at the file, see what's in there? And the attorney, I wasn't present, attorney called me. I said, just make a copy, see if you can do that. And so he made a copy. And what was uncovered through that, never been disclosed, were the prosecutor's notes of meetings with the forensic pathologist prior to trial, that the pathologist had actually concluded that when she was placed in the stream, she was already dead. This proved that the pathologist trial testimony was false, and that the prosecutor had known that before trial. Despite this evidence, Gibson had been present at the killings and was at least in part responsible for both murders. Given these circumstances, should his sentence of death be carried out? The second case I want to talk about is what really just talks about what's called mitigation in capital cases. And this case involves a gentleman by the name of Ronnie Gardner. Ronnie Gardner's first contact with the police was when he was burned by his parents when he was around 2 years old. When he was less than 6 years old, he started sniffing gas and glue with his older siblings. He abused alcohol, marijuana, and other drugs from this time and until he was 10 years old. He was placed in foster care from time to time because the family was dysfunctional. He committed a number of juvenile offenses. And when he was 12 years old, he was committed to the Utah State Hospital for a year in a locked facility. Throughout his teenage years, he was back and forth between foster care and juvenile hall. He would often run away from both placements. At one point, when he was placed in foster care, his foster father molested him and prostituted Ronnie. Several doctors who examined him concluded that he suffered from organic brain damage from the sniffing and huffing gas and glue. Very little of this evidence was presented to the jury. Ronnie committed his first adult crime before he was 20. While serving a prison sentence in 1984, he requested medical treatment and was taken to the University of Utah Hospital. He overpowered the guards, stole a scooter, and escaped. While on escape for several weeks, he entered a bar, robbed the owner, and killed him. He was captured and was facing a murder charge. When he was brought to a court hearing on the murder case, he grabbed a gun that had been placed under a water fountain in the basement lobby of the courthouse and assaulted the guards, who then fled. He entered into a clerk's office nearby seeking to escape, but there was no exit. He turned back toward the lobby. 2 attorneys were standing in the clerk's office at the time. When Ronnie ran by the front door, the 2 attorneys were standing behind that door to seek refuge. Startled by their presence, Ronnie pointed the gun at them and fired one shot, which killed one of the attorneys. Ronnie then fled out the front door to the lawn area, where he was shot by the police and captured. He was charged with capital murder for the death of the attorney. He pled guilty to second-degree murder for the bartender, but went to trial on the attorney's murder. Despite the family of the attorney requesting that he not receive the death penalty, Ronnie was convicted and sentenced to death in 1985 at the age of 24. Following years of legal challenges to his conviction and sentence, a federal magistrate determined that trial counsel had failed to develop and produce this extensive mitigating evidence that I talked about initially regarding both his youth and his tragic upbringing. Nevertheless, the court found that Ronnie was not prejudiced by the attorney's failure and affirmed the death penalty. In 2010, with all appeals exhausted, Ronnie sought clemency from the State Clemency Board. At the hearing, he presented all of this mitigation evidence, testimony from the parents of the victim attorney that he should not be executed. They did not want to see him executed, and extensive testimony about his changed behavior in prison during the almost 30 years since he had committed his crimes. The question for you is, should clemency be granted given these facts?
Okay, Andy, is that it for right now, I think?
That's it for now.
Okay, so thanks very much for the start. Hopefully you heard what all of the evidence that Andy put in, the description of the two cases, and as a group in the different quote jury rooms, hopefully there'll be enough people that you can remember everything that was said or talking about the cases. And whoever's the foreperson in your group will also have this same information in a written form that can be referred to by the foreperson. We're going to break into 6, we'll call them jury groups, but as you heard from Andy, the decision is really not going to be determining guilt or innocence or determining the fact that they both were given the death penalty. It is going to be deciding in the first case whether that death penalty should be set aside. That in the case of Tom Gibson, the member of the motorcycle gang in California, and in the second case with Ronnie Gardner, the question of whether clemency should be granted to him under the circumstances of his case. So those are the two things we will be asking each group to consider and talk about, and then make a decision on what they would recommend that be done by the judge. Either one, whether you set aside the death penalty, and on the other one, should the clemency be granted in the case of the death penalty. You will have 10 minutes to discuss and vote on the first case, and then you'll have 10 minutes to discuss and vote on the second case. We will automatically return after exactly 20 minutes, and Andy will tell us what actually happened in each of the cases and be open for any questions or anything you want to talk to him about from there on. So at this point, I'm just going to turn it over to Larry, who's going to give us the logistics on how we get out of this and into our groups.
I've got 6 rooms, and in each room, these will be the jury foreman: John Huffnagel, Harry Tether, John Vipon, Ken Wilcox, Ron Bodinson, and Gordie G. Andy, you are in room 3, and you will come back in. I will be in the main view, and there's one person that came in late, I think, will also be in the main view, and I'll try to get that person into a room if I'm technically able to. I would remind us that you're on a jury. By being on the jury, you've already agreed that you are not one way or another against the death penalty. So please don't discuss and spend all your time that I'm pro death penalty or against. You're on a jury trying to decide whether to give. Did I say that correctly, Andy?
Yes.
Okay, I'm
At
about
this
to
point,
open
yes.
all rooms. I will give you a warning 2 minutes, and you'll see it at the bottom of the screen. I'm keeping track. You'll have 20 minutes, 10 and 10. So here you go. This should be automatic. Okay, Gordie, you're on.
Yeah. Okay. So what we're going to do now is find out what each of the groups did. And in the first case, the one of Tom Gibson, the question of whether his sentence of death should be set aside. And so I had a group. We had a wonderful group, but for some reason we had only 3 of us. Well, really 4. So we had Bob Conway, Burke Moody and his wife, and myself. And we looked at the case and thought about it and what should be done and should his sentence of death be set aside. And our decision was, if we were the judge making that determination, that we thought that all 3 of us, all 4 of us thought that it should be set aside. So Huff, what about yours?
Ours was 6-zip. It should be set aside.
Okay. Ron?
Yes, our group had 3 lawyers and 3 laymen, and it was 6-zip to be set aside based mainly on prosecutorial misconduct or not allowing the defense opportunity to cross-examine the first decision.
Okay, Harry?
We had three members of the jury, Bill Biersack, Ron Gehrman, and Lenny Goldberg, and we all thought it should be set aside. The fact was there was no evidence of the actual murder by this fellow. I mean, being present doesn't give you any clear, no clear direct involvement by Gibson. So it was set aside.
Okay, Jonathan?
Thank you. We had a small group of three: Howard Clay, John Stableford, and Roger Walke and myself. Well, it was four. And we actually had lots of questions we wanted to send back through the jury foreman to the judge. We couldn't do that. I think our inclination was to set it aside, but we really needed more facts.
Okay, and then Larry, was it Ken was the last one?
Ken was the last one, and I was the last one. We had a main group. We had four
Okay.
in our group in the main.
Okay, well, Ken, what about your group?
Okay, we had a small group of three besides myself, Don Brown, Tom Hack, and Ron Matthews. We thought, since the guy was apparently clearly present at the killings and involved, our inclination was to get him retried again, rather than set the verdict aside altogether, and to sanction the prosecutor.
All right, Larry.
It's a sophisticated group. We had Harry Matthews, Art, Lucky, let me see, Rick Ackerley and myself, and we were four against the death penalty, and because of not presenting all the evidence. And in the second case,
No.
Well, no. First case. You're muted.
Sorry, I muted myself. I said sorry.
But yeah, no second case. So now, Andy, tell us what happened,
Okay, so
and also your involvement.
sure. So I wound up representing Tom starting in about 1991 when the case was in federal habeas. And none of that evidence about the prosecutor's misdeeds was known at that time, and probably never would have been known, but for the fact that my co-counsel from Seattle happened to be a fraternity brother of the then prosecutor, not the original prosecutor, who had tried the case 13 or 14 years before. So it was actually just totally kind of by fortuitous that we found that information out. Gibson had been tried with another defendant by the name of Donald Paradis. In federal court, we actually won, not on prosecutorial misconduct, but on the fact that the trial attorney should have found this information out. How, I don't know. Paradis won on prosecutorial misconduct. Both in the Ninth Circuit, both cases were, we won in the district court, in federal district court. When the case went up on appeal, the government appealed it because the conviction was set aside in addition to the death penalty. And when we showed up to argue the case, the first question to the prosecutor, because they went first because they were appealing, was, don't you think this case should be reversed, and are you willing to mediate the case? And so when I got up, my first response was, we're prepared to mediate. You should be affirmed, and the conviction set aside. And if you have any more questions, I'm glad to answer them. But basically, what happened is the case went back. We engaged in about 3 days of mediation, which is kind of unusual in criminal cases, and is very unusual in capital cases. But we did arrive at a resolution of the case. And my client had been in custody by then for about 20 years. And It wound up getting resolved in around 2000. He agreed to plead no contest to a second-degree murder, and everybody agreed that he would be released on after serving another like 2.5 years. But instead of being on death row, he wound up in a minimum security facility, wound up getting his commercial driver's license, wound up driving a truck from the prison, and was released actually on New Year's Eve in 2002. And we picked him up at the prison and got him out of Idaho, and he wound up going back to his family in California and leading a productive life as a truck driver for another 20 or so years, and died in his sleep from a heart attack. The side of the story that I always tell is that we remained in contact for a long time. One of the things that kind of shocked me was after he would call me from time to time going into a Home Depot. Too much pressure, too many people, from being isolated for so long and living in a prison setting, that it really would upset him. But then he became very, very conservative, and I'm not. And around 2016, I finally had to say, Tom, I'm dropping you off Facebook. I just can't take it anymore. So you know how the system is, but he wasn't. Nothing happened to the prosecutor. He was not sanctioned. The prosecutor eventually became a federal prosecutor. And Paradis's attorneys, he had some appointed attorneys who were civil litigators, and they sued the state. He wound up pleading guilty to an accessory, and he wound up getting roughly about $1 million from the state, but the prosecutor never was sanctioned. So that's kind of what happened. So for those of you who voted to do a retrial and see what was happening, that's kind of what wound up happening, and we went back to square one.
Okay. We're going to move on to the second case, the one of Ronnie Gardner. And the question was, should clemency be granted in his case? And so I'll start here. In our group, Bob Conway, Burke Moody, and myself, and Burke's wife, we all said you ought to grant a clemency.
We had an interesting discussion on that, and that was that we had both susses, which is just great. Bill, Clint, Daniel, Peter, the two Peters, Peter Hassinger and our other Peter, and I think that we ended up with a 4-2 decision, 4 granting clemency, 2 not.
Okay, Ron.
So we voted 6-0 for clemency, but there's a lot of emphasis on he had already spent 30 years in prison on death row, and we recognize the mitigation and the failure of the lawyer to present that originally, but someone can correct me, but I do think it seemed like punishment enough, 30 years. So we granted clemency.
Okay, Harry.
I think important to our group was the fact that the victim's family did not want the death penalty. And I guess in legal cases, that's important. If the victim needs to be satisfied, in this case, the victim voted against the death penalty. There were a lot of mitigating circumstances, from the being burned by the parents when he was young. In fact, he changed significantly in prison. So we were 4-0 in favor of clemency.
Okay, Jonathan?
I think there was some, well, uncertainty on part of all four of us. But I think we felt that there were mitigating circumstances, and John Stableford properly noted that his behavior had changed over that 30 years, and that was certainly another good indicator, but or perhaps the most important indicator, because it's very hard to determine really what his mental state was. He did pull the trigger and shoot two people. We really didn't know what was in his mind and how badly his mind was damaged by all the things that were presented.
Okay, Ken?
Well, Don Brown brought up the great line from the West Side Story that I'm depraved because I'm deprived. We decided that that did have some merit, despite the fact that there was an awful lot of mayhem that went on here. To not have brought this fellow's background into consideration at the time of sentencing would be a huge overlooking of something that's really critical. So we thought it should be either clemency or just reconsidered, a different sentence. But after 30 years, probably enough.
All right, so now we go
No.
back to Andy.
No, we got a seventh group.
Oh, I'm sorry, Larry, I
Got a seventh
apologize.
group.
Larry is so forgiving.
There was a minority opinion in our group. Harry and Rick and Art were all for clemency based on all the circumstances that you all talked about, and especially the 30 years and good behavior and long time. You must know that hard as it is for me, I'm against the death penalty, but in this case, I was on the board, and how it might influence you if you're right in the middle or you're on a jury where the death penalty. I was on the board of a psychiatric hospital for children that were all abused, and the psychiatrist I became good friends with, and I asked, why you time out? Why do you lock them up? Why do you put them in shackles? And he said, Larry, in spite of how you're brought up and what happens, you have to live in a society that has rules and bounds. That influenced me. So I said, this original jury gave him the death penalty, and those mitigating young circumstances didn't influence me because he still had to live within the bounds of society. So I voted to continue, and his clemency would not be granted in my case.
And the two that I had in mind, I was one of them, and Peter Krause was the other one. Both of us felt strongly that if we started to go, most everybody who has committed murder has those issues, and how far do you carry that? I think we all agreed that there's a lot of mitigating circumstances in terms of the time and the 30 years, but the sense that we had was that the two that dissented from the balance of the group just said, hey, this isn't a change in the circumstance.
And as I told you, our group had 3 lawyers, so we were very concerned with the fact that it was a lawyer who got shot.
I agree with that one.
Andy, the one thing I said in my group that I may be wrong, so when you comment, the original jury would have, in granting the death penalty or whoever did, would have known that the family of the killed person didn't want the death penalty. Am I correct in that?
They knew that, yes. It wasn't, yeah, it was family, it was more friends at that time, and we eventually met with the parents, elderly parents at the time, and presented additional information.
Okay, they jumped ahead of us on it, Andy. So why don't you now tell us, get us? So he's there asking for clemency. What happened?
So I wound up representing Ronnie from probably 1998 until 2010. Clemency was not granted. and Ronnie was subsequently executed by firing squad in Utah. And one of the things that we tried to present was, first of all, and I'm sorry for not being clear, but clemency did not necessarily mean that he would be out. He already had the other conviction that was a second-degree murder. It was in Utah, it's 5 to life. So he was probably going to serve the rest of his life in prison. It really was. It's hard. It was a tough clemency kind of proceeding because the bartender's family, where they had settled the case, they were pushing for the death penalty, which really, was not at something that was in front of, should have been in front of them, because that was not at issue. But the clemency board and the prosecutors brought them to the clemency hearing. I think that the fact that there were 2 murders separated at time, the fact that he had significant prior convictions, and that he was really out of control from really the time of 12 until 24 is what weighed heavily on the clemency board. Utah's a conservative state. The board is appointed by the governor. And so there was, it was an uphill battle at that point. Interestingly enough, on the side thing of the firing squad, there at the time Utah had a choice that was up to the person alone as to whether they wanted to do lethal injection or a firing squad. And there were such horror stories about lethal injection that my client chose to do firing squad. And as a result, we gave up a lot of challenges that have been successful over time, some on and off, to the methods of execution. The night that he was executed was an incredible personal night for me, because there was a vigil outside the prison, and Ronnie had turned from really a wild man into somebody who was very helpful to others in the prison. It's taught a lot of young people, don't do what I did. Interestingly enough, I think his turn came when we were doing and we put on a week-long trial about the mitigation evidence that wasn't presented to a judge. And when we walked in the first day of that trial, Ronnie said to the judge, "I want to withdraw my petition. I don't want to hear this." And the judge, stood back, took a recess, and said, "We're going to go ahead with the hearing. If you want to withdraw your petition down the road, we'll look at that. But we have everybody set. We've got a lot of resources used. We're going to have the hearing." After the hearing, I think Ronnie got some insight through all the testimony from family and friends and history and doctors and so on about how he got to be the way he was. And he, kind of changed. I don't know whether there's a result of that or not, but that night of his execution, I was approached by probably 5 ex-inmates in the prison who had been housed with Ronnie and felt that he was a force for good and got them out. And they were all, doing fairly well. And they were, just wanted to be there at this vigil for him. So it was a very moving kind of a tribute to him. But it was an uphill battle that we lost. And luckily for me, he did not want me to be a witness to the execution. It was a possibility, but he felt like if his lawyers were going to be there, then somebody from his family should be there as well. And he did not want that. So we did not witness that. I did speak with a number of people from the press who witnessed that. So
How old was he
was-
when he was killed?
he would have been 30. He would have been I want to say in his early 50s, 54.
50s,
Yeah, he was in his 50s by then. Um, and I don't know if any of you remember, but there's a wonderful book if you're interested in, this kind of death penalty stuff and just the history of it and so on. Norman Mailer wrote a book called The Executioner's Song about Gary Gilmore, who was one of the first people executed when they reinstated the death penalty in the mid 70s. And he was executed by firing squad in Utah. But it's a very good read about people's lives and the whole system and so on. And it's very well written.
We-
Andy, I
We,
have a question.
before we go on right there, we're gonna have time. Andy's gonna be around for at least another half hour, however long you want to ask questions. I think there's going to be a lot of interesting questions and amazing work and amazing answers from Andy. Before we do that, just a quick announcement. If Huff, you can just talk to us about our next Zoom presentation, which is going to be on Thursday, January 16th of 2025. And by our classmate, Bill and Daniel.
That's correct. And we're looking forward to it. We decided not to have a get together in December because it's a busy time for so many of us. And we thought that it would be great to be able to do this. And Bill is here with me tonight. And I think he might be able to give a little better sense of what he's going to talk about. But we're excited about his work with Mount Auburn Cemetery and the Historical Society. And Bill, you may want to just put in a little bit of a plug as to what you wish to talk about. We've had some conversations, and it really is. It's going to be a great talk. But you got to unmute yourself first.
Well, I put together a couple of sentences about this. It's not going to be nearly as dramatic as what we've just been through, or I don't think it'll be very controversial. But I want to share with you all my over 45 years of working either as an employee or as a trustee of 6 Massachusetts organizations, all helping to preserve, enhance, expand, and make available to the public the cultural treasures of the Massachusetts Commonwealth. Natural areas, designed landscapes, historic houses, and archival materials. These range from Field Farm in Williamstown to Castle Hill and Crane Beach in Ipswich, beaches on Nantucket and Martha's Vineyard, and the nation's first landscape cemetery, Mount Auburn in Cambridge. They include the nation's first preserved landscape, the Boston Common, and thousands of documents and objects at the country's first historical society, the Massachusetts Historical Society, including the papers of our 2nd and 6th presidents, John and John Quincy Adams, and their descendants, and the architectural drawings and the all-important garden book of our 3rd president, Thomas Jefferson. I'll show a lot of pictures and share stories of my adventures across the state, challenges and successes. So look forward to seeing
Thank you,
you all.
Bill. And one of the things that was great about our 50th reunion before you took us all to the Historical Society in Massachusetts, and we got to handle documents by John Adams and by Ephraim Williams, and so it was Paul Revere's original letter. So it just great stuff, and I think it's going to be a terrific thing. And I just thank you for just giving us an idea of what it's going to be about. But I think we get back now to Andy, and thank you for this presentation. And I think there's a lot of questions that are coming up. So let's open it up to the questions.
Andy, Tom Hack here. Question: how many people on average are actually executed pursuant to these death penalty trials in the United States each year?
It's varied quite a bit. It's way down from what it used to be. It used to be in the 100, 200. It's now down I think this year there are less than 15 so far. There are more more states have done away with the death penalty.
Right.
A number of governors have imposed moratoriums on the death penalty. They don't have the power to commute death sentences. So in California, for example, where there are probably 800 people on the death row facing death sentences, there has not been an execution since 2006.
Wow. Okay. Interesting.
Andy, hi, it's Warren.
Uh,
I want to remind you that back in, I think our senior year, you said I'd end up as a fat cigar smoking capitalist. You got 1 out of 3 capitalists. But I did
You're
want to ask
thin. That's the
you-
only difference.
I did want to ask you about the path that you took, and I know I read a little paragraph on it, but the path that you took from college to doing what you're doing now.
Sure. So I'll try to be quick. I went to graduate school and got a PhD in development economics. From there, I did that in 4 years. I didn't get my degree until 73, but in 71, I started teaching. I taught at a state school called Eastern Washington for a year, taught at San Jose State for a couple of years. A number of us got fired from San Jose State for not anti-war stuff, but kind of more like union organizing, trying to keep our department from being run from the top, from the administration, and be independent. We wound up suing. By the time the case went to trial, I'd been an attorney for 3 years. I went to law school with the idea of going back to do law and economics, and so I'd be more marketable as an attorney. As somebody who had both the economics background and a law background to teach the interface of law and economics in our society. And my second year of law school, I had a friend, and she had a trial in Alameda. I went to Berkeley, and she had a trial in Alameda County, criminal case. I got hooked. I worked with her husband on an externship the next semester, and then I wound up just going into my 3rd year working with other criminal defense attorneys. I opened up a criminal defense practice, joined with friends in the 80s. We wound up doing general criminal defense, did one capital case for a client who was convicted of murders in 1978 in California and is still on death row, not being executed. So that's kind of the way I wound up doing it. And when I moved up here, there was not very many people who did capital litigation and capital appeals, and so I wound up getting involved in that in the early 90s, and then I stayed involved.
Thank you.
Andy?
Gordie, Lenny was the first one with his hand up.
Oh,
I was kind of gonna ask the same thing, which is that particularly in how deeply you got into death penalty litigation. And I also, just coming out of our legal discussion, to keep it more on the subject itself, is how much is in sentencing, how much is victim testimony, victim feelings about that taken into account. And but anyway, your involvement in death penalty also is very interesting.
So there's been a real kind of revolution about victims' rights in all sorts of ways in the states. Most states now have amended their constitutions even to allow victims to have rights during even non-capital cases. So victims have a lot of say in what happens. And that's one of the things that I feel is one of the reasons there shouldn't be a death penalty, is because it's so random. You shoot somebody and you kill somebody whose family doesn't believe in the death penalty, and sometimes prosecutors won't even seek the death penalty based on that. Other times you have people who are adamant about having the death penalty carried out, and the family will pursue that for a long time, and prosecutors generally will follow that, whether it's a more heinous or less heinous, or there are more excuses for it or not excuses for the murder. So victims have a lot of say. They don't have the final say, and some prosecutors will just say, we're not going to listen to it. It was unusual in this case that the prosecutors did not want to listen to the family. They were hell-bent. I mean, Gardner was, you got to remember, he escaped from prison, which had everybody upset. He killed somebody while he was on escape. Then he escaped again. Everybody looked bad around the whole judicial system and the law enforcement. So they were really, he was, wasn't, the fact that the families didn't want it was just not going to override the general bad publicity about him.
Rich Gehrman was next up.
Inaccurate.
Right. Hi, Andy. Great to see you again. Been a while.
See you.
Something that jumped out at me that I had never thought about before. Maybe somebody has a comment or some expertise in. As I'm used to thinking about kids like Gardner who were like tortured when they were young, and how that scrambles your brain, and then it's just a tip of the iceberg of all the other kind of unorganized experiences kids have. And then they get into some prison later on in life, in adult life, and the structure apparently really has a beneficial effect and allows them to really start, developing as a human being, maybe for the first time. I've only thought about that in terms of infants and toddlers, maybe adolescents, but never thought about it in terms of older people who are in highly structured, not very pleasant, but very structured situations when their life has been chaos up to that point. And so it just was an interesting insight to see that both of these cases, but particularly Gardner, it seems like the structure really allowed them to become kind of the human being maybe they started out to be.
That's really true. So a lot of times, there are a lot of people who I represent who I don't necessarily think, because we don't do very much rehabilitation in the system, should be let out. I mean, I'm not, I go back and forth. In Europe, the maximum sentences are 20, 30 years. They're not that here. Somebody like Ronnie, who has organic brain damage, does function a lot better in a controlled kind of situation. I don't think he was a risk there. Would he have been a risk outside? I don't know. That's one of the big things. I mean, my sciences at Williams were, I think, geology and math. It was what I took. I didn't do stars. I just did rocks. But I've learned a lot in what I've been doing about the brain and how the brain functions. And I think that's been one of the things intellectually that I've really enjoyed learning about that. I mean, I feel like in our day and age, we're learning a lot about what's going on in the universe up at black holes, but we're also learning a lot about what goes in our brains. And so, somebody like Ronnie doesn't have the control because of what happened to him when he was young and the huffing. That's things he did. I mean, I don't know if you can call somebody who's 6 or 7 who starts huffing glue and gas making a decision or not, but those things have an impact on your brain structure, and it has an impact on your ability to function in society.
Peter Krause, you're next. You have to unmute.
So thank you, Andy. That was really great. Just for the record, I am against the death penalty, but the rules were that you had to go into this sort of neutral. I also want to take a quick opportunity to just say hi to Dan Brown. He was my roommate freshman year along with John Wolp. And I missed your talk, Don, but I got the recording of it, and really excellent. So I just wanted to mention that.
Roger, you're up.
Okay. Andy, thanks. That was really fascinating. And I'm also mostly against the death penalty, and I support your work. But the question I have is kind of technical. It's about Ronnie Gardner. In his case, was he never examined for mental competence by either side?
No, he wasn't. And quite honestly, I don't know your background, but mental competence, incompetency in a proceeding is really measured by two things. Can you understand what's going on in the proceedings? As do you know that it's a judge and it's a jury and it's a prosecutor, things like that. And then the second part of it is, are you mentally competent to assist your attorneys? So I've had clients who are, not been competent because they're just, they see things and do things. I had one client who was deemed not to be not competent enough to be executed. He had been convicted. The lawyer hadn't done anything about his mental competency, but he was convinced that the person he killed was still alive. And other things. And we had in federal court, we had a long hearing on whether he was competent to waive his appeals because he wanted to waive his appeals, or competent to be executed. So mental competency is really different than, what were you thinking about? What was your criminal responsibility at the time you committed the act? So very few people are found to be incompetent to proceed to trial, but he wasn't examined at the time of trial for things like organic brain disorder, bipolar, any kind of mental background wasn't done by his trial attorneys. And we were the reason I got involved in the case was nobody in Utah wanted to handle it because the trial attorney one of the trial attorneys, or two brothers, one had become a judge in the Salt Lake court system. And so no lawyer in Salt Lake was willing to take the case. And so that's one of the ways I got involved.
Peter, did you raise your hand again? Have a follow-up?
I did. Thank you. Yeah, follow-up question. I just
Bill
wondering.
Willett has a question too. Bill Willett's got a question too. Yeah,
right.
Go ahead.
This is real quick. What do you think is going to happen in the future? Do you think the death penalty will be abolished in this country or not?
No, I don't. I mean, that's probably coming from Idaho, where I live now. I think in a lot of states they've moved away and have abolished the death penalty, but I do not think it will be totally abolished certainly not in Idaho and a lot of other states. And I don't think it'll be abolished on the federal system. I mean, take a look at the politics have shifted a little bit, but Bill Clinton, I'll try to be short on this, but Bill Clinton, when he was running for president, went back to sign death warrants as the governor of Arkansas for 3 people who would not have been executed because they were intellectually disabled. Used to be mentally retarded. It's intellectually disabled now. So when the court case came out that you couldn't execute somebody who was intellectually disabled, that was like 7 or 8 years after Bill Clinton had gone back to do that. Obama was not against the death penalty. Biden, so Democrats and Republicans, when they're at national levels, they're not. I don't know, Lenny, you're in California, Gavin Newsom, I don't know. A lot of governors have put moratoriums on because it's so unfair.
But Biden had promised to remove it at the federal level, and it's not done it.
But did not. Actually his Justice Department sought the death penalty, for the in one case, the synagogue shooter in Pittsburgh, I think. So they've done that.
Boston Marathon.
There were several
Marathon
ballot measures in California over several years that failed to abolish the death penalty.
Right.
One of my friends who was a state senator, Lonnie Hancock, was in the state senate, got them to put it on the ballot, from the legislature, but it failed, I believe, twice. Is that right, Randy? You might know that more than I do.
That's right.
and it failed, I think, by about 53% one time. It was pretty
Yeah.
close.
Yeah, it was close.
Bill Willett, did you have a question?
Yes, I was curious. Well, thank you, by the way, Andy, for a fascinating presentation. Who provided the gun to Ronnie? And if so, was he or she ever apprehended? And what was their criminal liability in all of this?
Never apprehended. Nobody ever said who it was. I have some suspicions of who it was. And I would say, without going into great detail, as far as gender goes, it was I believe it was probably a female, and it was left on a water fountain underneath the water fountain, and it was a crappy old 22.
Oh. All right, but kill that attorney. All right, thank you.
And it killed Jerry, who was not involved in his case at all. Just randomly happened to be down in the clerk's office getting some paperwork done. And the other attorney who was standing next to him really suffered from, survivor's guilt. I think they were good friends. He was very supportive of Ronnie because of, as a friend, and he knew his friend was not in favor of the death penalty.
Andy, I have a quick question. Before you went to Williams, pre-Williams and after Williams, what was your opinion of the death penalty, and has it evolved, or have you always been against the death penalty?
God, I don't think I ever thought about it before I went to Williams, but I didn't think about much before I went to Williams. I was
an honest man.
I was raised in Brooklyn. I went to a school called Poly Prep, and I think I took Latin, French, math, English. I think, I had one course in social studies. So I didn't really, I learned how to study and do things, but I didn't really learn how to think. Williams really changed that. I remember being in a reading group, reading Crisis in Black and White, outside of the class. And that changed it. Lenny certainly had an impact on me, the junior advisors, and then I took off from there. And so, once there, then I kind of was opposed to death penalty. And I'm opposed to it in all circumstances. It's hard to make a choice, and certainly the way it's been delivered in our society. And I'm fortunate in the sense that I don't practice down south. If you ever read Just Mercies about Brian Stevenson and the battles that they go through, very different racial stuff, more than we have up in Idaho.
Let me add to that. I was going to mention that earlier. Good point. Brian Stevenson has done some remarkable work. He was a Harvard lawyer, came south. He's a client and a friend down the street. There's a difference between court cases that don't go your way or complicated for a variety of technical reasons or prosecutorial conduct. And there's another category of where whole categories of people are adjudicated unfairly, regardless of the record, and people die. And Brian has done an incredible job of actually just working Black incarceration and finding case after case after case where the accused was convicted without proper evidence. So he's since had tens of millions of dollars given to him, and has produced a couple of major museum components that are receiving enormous visitation from across the world, telling quite a story. So that one, the movie is good. If you ever come south, you come to my town, you got to go to the EJI Museum. It's breathtaking, tells a heck of a story, and Brian is one of my heroes in life.
No, he's incredible. And I actually have a federal judge that I appear in front of here in Idaho a lot, who recently took a journey south to see all of those things. He's, so it's, definitely true. But the other thing is, just say, if you ever see an article and you say somebody confessed, and then say, oh, they had to have done it. We had somebody on the row here that I wasn't involved in, but he was on the row for 20 years for a murder that he didn't commit, but he confessed to. And it took a lot of work from a lot of people. And eventually the prosecutor said he didn't do it and came out that way. So if you see things in the press and people confess, sometimes it's true, but a lot of times it's not. So be aware.
So Larry, it looks like we have the group hooked on legal cases. So maybe there's a divorce attorney in our group who could come in and present 2 great divorce cases, and we could all decide division of property, child custody. Would that be interesting?
You're sick. You're sick, Bodinson.
I said
another topic
when I moved up to Idaho, I only done criminal defense work, but I moved to a small town and just really abandoned my, didn't abandon, but moved from my practice. And I thought, oh, small town, I'm going to have to do work. And I had one divorce case, but there were no kids involved. And as I said, I had the boy toy, and the established attorney had the wealthier older woman. So that was when a new boy on the block. I wound up with the person who had no money. But people say to me, you do all these horrible cases, and I mean, I do a lot of child abuse cases and assaults and things that are horrible. And I say, well, sometimes I just couldn't do a divorce. I could do these things, but I couldn't do a divorce.
I just wrote to Gordie. We've got time for about one more question. And then if Andy would stay and people want to stay and chat, I have to run to a meeting, and I can leave this open and people can just leave when they want. But that's what, if Andy would stay after the 6:30 time and other people want to stay and just chat, we can do that. But does anybody have a last question?
A huge thank you to Andy. It's amazing and wonderful the work you do.
Terrific presentation.
Yep. Thank
People
you.
from the mountain states do good work, Gordie.
Well, hold on. There's Mount Sunflower in Kansas that's higher than any.
So, Andy,
Ron, if you stay on, I'll tell you a story about Mount Sunflower, but I won't do it now.
Are you willing to stay on, Andy?
Yeah, sure. Absolutely.
So if people want to stay on, I'm going to.
Thank you all.
I don't know whether I can sign off or not. John, are you going to stay off?
I've got to go too, but I think we're okay because it's being left on. Alan is our